Ciara Torres-Spelliscy. I'm an associate professor of law at Stetson University College of Law. So ever since John Roberts and Sam Alito joined the court, there has been a deregulation of campaign finance law. Before they got there, just in 2003, there were actually dual decisions, the Beaumont decision and the McConnell decision, that upheld very long-standing and some new campaign finance restrictions. And 3 years later, it didn't take them very long, in 2006, they started undoing the campaign finance law. It started with a case called Randall, which didn't catch many people's attention. It was an attempt to litigate Buckley from the left, and there was, whether that would have worked with the Rehnquist court is an open question, of course, but with the new justices on the bench, it was a doomed enterprise. And right now, I think the record is something like 7-0 in terms of litigating campaign finance cases. They've been at least partially struck down by this court. So we have seen an increase in outside spending. A lot of this is attributable to Citizens United and then to a DC Circuit case called Speech Now. And that's what gave rise to the super PACs. A super PAC is different than a regular PAC because they can take in unlimited funds. So they can take in money from corporations and unions and from wealthy individuals. And so the sky is really the limit with how much money a super PAC can raise. And what we saw in the 2012 election was the rise of single candidate super PACs. So one of the big open questions of law is, well, if you have someone who's spending millions, and in the case of, for example, with Sheldon Adelson, nearly $100 million poured into one election, the idea that the beneficiary of that would not feel beholden to that spender seems, I think, comic to many people, but not to the 5 justices on the Supreme Court who matter. So I think until we get a change of personalities on the court, we are stuck with a very stylized notion that if it's independent spending, it can't be corrupted. It could be the soft money ban under BICRA. So that would allow parties to take unlimited funds in a similar fashion to what the super PACs can do right now. That has so far survived, but the trajectory of the court seems to be in a deregulatory direction. Sure. So, I mean, one of the things that's, I think, very interesting about the Citizens United case is it started with a nonprofit that wanted to run a documentary. And there were many sort of narrow statutory ways that the court could have ruled in that case. They could have said that this type of nonprofit was not meant to be covered by the law. They could have said documentaries were not meant to be covered by a law that was really aimed at election ads. But the court didn't take any of those narrow ways out. They took the broadest approach possible, which allowed corporations, whether they were a single person S corporation all the way to a multinational corporation, and said that they had a First Amendment right to speak in politics. Well, for the bigger entities in that world, the publicly traded companies, this raises a host of corporate law questions. So one of the things that I work on is corporate governance responses to Citizens United. And from a corporate law point of view, there are at least 3 problems that corporate political spending raise. 1, there's a lack of transparency. 2, there's a lack of consent. And 3, there's a lack of internal controls. And so what does that mean in plain English? Number 1, I can't see it if I'm a shareholder. There's this huge dark money problem where corporations and other entities are spending through opaque intermediaries, which means that as a shareholder, I just can't see that my company is spending. The second problem, a lack of consent. They don't have to come to me as a shareholder and ask for me to say yes or no, either before or after the fact. And then finally, a lack of internal controls means that in many corporations, the board never considers it on my behalf either. So the spending just happens and no one is really held accountable for it. So one of the things that I work on is trying to get the Securities and Exchange Commission to promulgate a new rule on corporate political spending and to make it transparent at long last. And so there's been a petition pending at the SEC for a couple of years. It was put in by 10 corporate law professors. And this summer, we're going to hit 1 million public comments demanding the SEC act. So far, they have not, but I have full faith that they will eventually do the right thing. So ACS is just a fabulous organization. They were, when I was at the Brennan Center, they were the ones who got me some of my first opportunities to speak in public. And I think they really help young scholars to get their work out. And then I think they do an invaluable networking opportunity for students like those at Stetson.